Okay, over to you, Dharmender.
Okay, great. This is a part two of the session we had last week of the estate planning. We covered aspects leading up to um, the need for creating the power of attorneys, different kinds of power of attorneys, what happens when you don't, and stuff like that. And this week we'll continue on in the phase of after the power of attorneys are all done, what comes after that, when the person no longer is there, how the law acts on it, and what are the lineage of various activities that go on to help set things up for planning. Just so this is very basic, what I'm setting up and sharing information here. But I would say a good 95% of people, maybe even 99% of the people are covered in this. Special cases, maybe because of the special needs, or maybe because of the amount of wishes or well involved decisions that they want to make are complex, then it takes a little bit more proficiency in setting this up and understanding various things that are available. I probably just scratched the surface. There's plethora of lawyers that do nothing but this, obviously for a reason, because tax laws are very complicated. And done right, people can escape taxes, living or otherwise, for a very extended period of time. And that's the unfortunate part of these laws, the way they're set up. Somebody was saying the other day, I was listening to somebody, only the uninformed people pay taxes when it comes to flow downs or estate plannings and all that. So anyway, where I wanted to kind of bring the topic again is a lot of times people spend a lot of energy in their active lifestyle, during their active life, when they have capability to plan or do stuff during their 20s, 30s, 40s, 50s, in all their adult life, accumulating the wealth, controlling the health choices that they make, supporting the dependents, choosing the charitable activities, everything that they can affect while they are have the capability to make the choices. The equally important is what happens when you're not able to make those choices, who controls these activities in your absence. So briefly, we touched about power of attorney while you're alive sets things up for various activities. But then I'm just going to fast forward to, we'll assume that the power of attorneys are created, various kinds. But if now comes when the person expired, what happens? It's kind of critical to understand for all of us, irrespective of the size of the assets that you have. When the person no longer is there, how does the law work? And who controls various things that happen? It could be your dog. It could be your, coin collections, whatever those are. when you don't speak for it, what happens? Now, in situations like how we grew up in India, a lot of these just happen, based on how they think is the most equitable thing to do. Even though you might have written down in will, they probably don't even care and spread it anyway in the way what society accepts the norm to be. But when it comes to America and probably more and more in India nowadays too, there are legal actions that happen right after the person dies in distributing the assets. So in US, what's the assets are distributed in what's either called, it goes through what's called probation. Probation is an act by which law allows for distribution. So the painful act of, if you don't plan for it, probate is the most costliest way and most ineffective way for your assets to reach your beneficiaries. Now, I'm now talking about what happens if you didn't plan for it. The law goes through what's called a non-probate estate or a probate estate, meaning if you don't speak for anything, law already has a lineage of how and who the assets are distributed to. So in a non-probate estate, the way these things are distributed is the law will decide that not if you didn't speak for it, meaning if your will property is not already established, imagine coin collection, imagine a house. Who receives it and how they are distributed is based on the operational law and testamentary substitute, which is a legal way of saying who is the beneficiary that law recognizes to give it. If it's a probate probate estate means you wrote in your will. Law recognizes your will as in last wish that you wrote down in a piece of paper, which the law honors, will not question, unless it's illegal to do it, will not question why you decided to give coin collection to your neighbor. They'll just, because it's already spoken for, it's the person who receives it can read the will. They said this coin collection comes to me because he wrote it in the will, and the person takes a possession. If not, you can go to court and court will give you that. That is how your wish will be carried forward. But a property passing by your will only transfers the money. And the way these things go is the will is what they don't know, meaning officially, what they don't know where an asset will go. It's a complicated way of saying if a will already speaks for it, that is not in the pool of what law decides to distribute. So a good planner will list everything in their planning, in the will, every asset that they would like it to be distributed so that what's not in the will becomes zero. So if for some reason, if let's say Michael Jackson never spoke of what to do with his image of his photo and who has the rights for it. If he didn't speak for it, that's not in the will. Now comes what happens with that asset. Now law will take care of complicated way of doing it. Obviously, people are going to sue for each other and saying, I'm the son, I'm the daughter, he told me the other day. It can get complicated. Easiest way of saying is, if you can plan for it, put it in the will, and make every asset speak for it, your wish will be carried forward. That's the most simplest and easiest way to say it. So what is the probate? Probate is a legal process that takes place after someone dies. So ideally speaking, when the probate happens, if every asset is already spoken for, there's nothing for the law to distribute. You don't need a probate officer. You don't need go to court. None of that. Boom, boom, boom. Everything happens in 15 minutes, and you're done. So
Question, Dharmender.
assets are distributed after. So the way the probate goes is if there was any asset that are left over, they are distributed after the expenses and debts as per the will. This is where it gets complicated. Meaning the court will appoint an administrator. Could be, some MBA somewhere or a lawyer. So they may even have some people that are already there. They may be charging $200 an hour just to look through everything. They make a living just booking the hours. So there's a $5,000, $8,000, $10,000 they're just basically charging anyway. After all those expenses are paid and all the services that they in turn may be hiring, because as you can see, their friends could be there and the guy is going to hire a appraiser and this, all those as they are paid for, those expenses that are paid for, what's remaining is what goes to the beneficiary of what the law then decides the beneficiary is. So simplest way of saying, as I said, 99% of the people probably are covered. List everything in the will and you're done. So probate rarely benefits the beneficiaries because the cost of services provided, they milk it. Okay, so probate makes sense only if your estate has complicated problems, such as many debts that can't easily be paid from the property you leave. So again, sometimes people who have taken a lot of different complicated loans and they have pledged different properties into 15 different places, they intentionally may leave it up so that let the probate officer decide who gets how and who gets it, but then they would have, that becomes part of planning to drain it up. Again, we don't have to cover that, but as we were saying, it's better to just avoid the probate. Probate, how do you avoid probate? Probate is if you have a typed up will, again, any will, whether it's handwritten or not, if it's established that it is from the person deceased, court generally honors it. It's because it's subject to interpretation, beneficiaries may fight it out and this and that. It's much better and easier for everybody. As a suggestion, have a typed up will, not handwritten, so it's not subject to some doctor's handwriting that is confusing or anything, in clear terms with clear beneficiaries. So your wish of who needs to get what is carried forward. A revocable living trust is another way that you can avoid the probate, meaning while you're living, you put your assets into a revocable trust of which you still are in charge. I'll cover the differences between revocable and irrevocable. Revocable is as good as just having a ledger. There's no tax protection. There's no benefit other than just having categorized it in a place, and then you can put the terms of that trust for certain things to trigger when the person is no longer there. So in other words, it can become a prelude to what can happen after the person deceases. So the revocable living trust is it's a trust property that is not part of your probate estate. Meaning, if you already spoken for it, then it's not part of what law will say. How do I distribute this? No, you already spoke for it. After your death, trustees transfer the trust property to the family or friends that you left it for, without any probate. So in other words, it's already spoken for, it's done. The trust document is similar to a will specify who you want the property to inherit. So again, it's a clearer, easier way would, while living, to either put everything in living will so that, let's say a house, just for example, and you wanted to go to your son. When it's in the will, as you can see, the son or somebody has to carry those actions in producing the death certificate, showing the will, and then go to the appropriate offices and take the deed transferred over to the person's name. If it's already in the trust, you did half the work already, because it's just a matter of taking the ownership of the trust or executing what's already written in what's already in the trust just goes into the person. The advantage of being in trust is it can give you X amount of overlap days. It doesn't have to be carried very immediately. Okay. So another way to do that, to avoid the probate, is pay on death accounts or registrations. Meaning, let's say you have a checking account. You could already put a beneficiary listed in that account with TD Bank. So the TD Bank would immediately recognize the person who needs to get to, maybe it's your neighbor, as long as they can provide the death certificate, and then the beneficiary listed will get that. So that's another way to not have a leftover property that is not spoken for already, which anything left over, you're basically asking the government to decide who gets it. Or,
Hey, Dharmender, can I ask a question? Sorry
yeah,
to
go ahead.
Yeah. So that's a good point. So let's say if I have a will and I say, my beneficiary is my wife, right? But
Yeah,
let's say in the bank account, I have some other name, like say my son listed as beneficiary. So
yeah.
then which one will supersede?
Beneficiary in the account.
Account. Okay. All right. Okay, good. Thanks. And one other thing is, so let's say, because I set up my living will and all that with the lawyer, right?
Yeah,
So if I specify, let's say I have these 5 accounts, right? Stock, 401k, IRA, all that stuff, right?
yeah, yeah.
But let's say if I didn't specify 2 other accounts, what happens to those?
They
Is the
become part
same?
of probate. They become part of probate.
See, because that's the whole thing. I was telling the lawyer, I'll give you all the details, and she's like, no, I don't need to know that. So I need to go back to her and then have her list all the accounts at least, right?
Right.
Amounts don't need to be there, right?
Right. Or easiest way would be to just go to the account institution where that is and list the beneficiary.
And basically, okay, makes
Yeah,
sense. Okay, all
that's a
right,
nice
thanks.
way. The
Okay.
thing with the will is another way to basically categorize and make it, you would have made a folder, let's say big binder or something. All of the information that's listed in there. I mean, I travel to India a lot, right? So the better example would be when I go to India and I know for X amount of months, I'm basically going to be away from my office and things that I need to sign and all those. I would have basically prepared a binder of information with one for my personal life, one for the office, where if I'm not there, they can survive. Every little info, passwords and who has the account, who is the trustee for 401k, everything is there already. So in a way, it's like going to extended tour to India, which probably I never will come back. That's how you could look at it. But if idea is you want people who are left behind to be able to survive or carry on your wishes or not be searching for where is the keypad code to open up the safe. Well, if you didn't leave the number, what are they going to do? One, they need to know where the safe is. The second is they got to break it in. If they are breaking it in, now the question comes in, who are the beneficiaries? Is the son and daughter going to say, no, we have more right than the neighbor who says, he told me that safe was going to be mine, so I'm going to come in to break. And even though he didn't leave me the key, but it's mine. Now the neighbor has to establish by law, and the law has to agree, and they have to, instead of all that, it's much better to just make a big binder. Everything is spoken for, and yeah, go ahead, please.
Chairman, I have a question. If all my 401ks and Vanguard and Fidelity, all the accounts have beneficiary clearly stated.
Yeah.
Also, I have a will which says that who will inherit my house.
Yeah.
And everything else is stated in the will also.
Right.
Is there any need for living trust? The only thing I haven't listed is my furniture and my pillows and bed. I don't care about that.
Right. Again,
Do I need a trust? That's my question.
In that simple example you gave, answer is no. So 99% of the people, and you'll see how I'm going to lay it out. Even
So the answer is no, you said, am I right?
Yeah, your answer is no. You don't. If it's simple like that, you don't need it. Including, you probably want to write down who gets the pillow if that's your favorite pillow, right? I'm just joking.
Okay, Dharmender, I have another question.
Yeah.
So you have a will in which you have written that your home will go to your kids, two of them, right? And you don't have a living trust,
Right.
or you have a living trust in which you have that one. Both two scenarios. Is there a need for probate in either one of them?
No. Once you account for it, then it's not in
Probate will not come into play.
Because probate is that which is not spoken for. If you think of it like that, it's a negative. If all assets are already accounted for and you list it and it goes to who, and what's remaining is like a safety net.
Yeah, the things that I don't care about, like my favorite pillow, whoever wants to get it. That's fine.
Right. Then that's fine.
Yeah.
But
Okay.
still, I agree with you. There's no need for probate, but still, state has to look at the will and then whatever you call it, approve it. Am I right?
Right, but it's a very rudimentary step. I mean, and also you'll see it further. They actually allow up to $150,000 of assets that they don't even allocate people for that, because they know many people probably didn't plan right in their life, and so they allow certain cushion before the process of grinding process of probate is invoked.
But Dharmender, we are talking about millions here.
Well, no, 150,000.
I know we are talking about millions, so 150,000 is not.
I'll come to the millions. How you probably want to keep your millions.
Right.
I'll come to that. So anyway, as you can see, anything that's not already spoken for, government has to do something with it, right? Otherwise, you can't have a plethora of unspoken, unclaimed properties. They got to do something with it. That's what a probate is. Yeah, go ahead.
I have a question. Maybe whether you will cover later on, that's okay. There is a possibility that there could be multiple wills. So how do you handle the, maybe either because of time frame or two different people produce a different will, and then has to be claim as to which is the right will and which is the latest will. This is one question. You don't have to answer immediately. You can do it later on. And secondly, there is possibility of a generic will, in which case you mentioned that all should be listed for in the will. But I myself have gone to a lawyer and he has prepared a more generic will where he says you will keep an account.
For some reason, you're breaking up.
I think I'll extend what he's trying to say. He's trying to say you have a generic will which says that your property will be given to your kids. 50-50 or one third, one third, one third, something like that,
Right.
which does not tell exactly what is going to who. Versus you have a list of properties and then you say that this one will go to this person, this one will go to this person,
Right.
right? He's trying to say, is generic will okay?
Well, the answer is this. If you think of it like, if you leave that instruction, okay,
Yeah.
to somebody, let's say you're going to India, and then you're going to tell somebody, hey, look, I got a house and I'm just going to make 3 rooms and you can live in these 3 rooms. Now, if it matters to you who lives in a specific room, you want to be able to clearly say, identify the room and then put the name to it. If it doesn't matter to you, then you're basically leaving it up to those 3 people either to fight it out, or they'll say, all right, you take the first one, I take the second one, and they don't care. So it depends on how much you care. And also it depends on the receiving people, how much do they care, because they can go, if it's ambiguous, opens up for the problem, discussion, opens up for fight, opens up, and it depends on who is litigious and who is taking that extra step and next step to go to court and make the court decide which room do they really like. Did I answer that question?
Somewhat,
Yeah.
yes. So, but
So
they
you were
can also
saying-
not agree for which room they want to take, and in this case, homes, and they can say that let us sell and distribute the proceeds if we don't agree on that.
It depends on how they want to settle. In fact, I'm right now involved in trying to mediate in my relatives to do that. Exactly what you just said. Even though the will clearly states who gets what, right?
Yeah.
But the people who are surviving are claiming that it's not equal. Okay, now when legally speaking, not equal is not the reason. It doesn't matter. One person could be getting 90%, the other person could be getting 10%. So, and if that's how you want to interpret to say that's the last wish the person wrote, thereby I really don't care, you could stick to it. But in the society, in the friendship, in the community that you move around, if you are sensitive into thinking you got 90%, the other person got only 10%, and thereby you may be saying, you know what, although the person wrote like that, fine, let's do it in a different way. So what I'm trying to lay it out is what you write down is your wish. How it gets implemented, you're only lucky if you get implemented like that, right? It can be just as easy as people will say, fine, and it's a free money, we just got it anyway, let's take it. Who are receiving, I'm talking. Or the person who's receiving could be saying, no, all these things that I did to my father and he never accounted for, and he owes me so much money, and you took advantage of him being there and I was not, and thereby I'm just going to play foul and I need more money. Well, if you have a claim like that, they can go to court on that. They could lose because the will overrides everything. That's what, again, it all depends on how good a lawyer you bring. It depends on, they could be saying, look, that will is written in 1998 and there's a subsequent will that they wrote and it's in 2010 and look at it when everything is written differently. So I'm walking now back to one of the questions the person asked. How do you know which one is latest? Answer is you don't know. So best thing to do is to notarize it, have a lot of witnesses, and register it in a government place or a lawyer, and get into the habit of writing. If you are about to amend or cancel the old one, cite it that you had written a will 1998, I now make it null and void, and this is new, and thereby, if somebody were to be reading the documents, it clearly shows that you are aware you wrote something and now you want to change your mind, and you clearly said, I don't like what I wrote in 1998. If you don't have it like that, and I'm the lawyer, I'm going to be saying, look, on that day, somebody put a gun to his head and he wrote it like that. And today what he wrote is right. Now, I could be just saying it, and I could take it to the court, and court will have to decide, depending on who buys the judge, depends on if judge was fighting with his wife that day. All those come into picture. So coming back to our example, simpler the terms, clearer the instructions, and like making accounts with the beneficiary clearly noted. That is indisputable. In other words, if you have a TD Bank checking account and the beneficiary is listed there, that's not up to the dispute. There's nothing to dispute there. But if you just go, I have 3 accounts, and then amount is so and so, so and so, and then there's gold, maybe 2 chains here and then 8 chains there. Ambiguous, what I'm talking about.
But in terms of the will, there are 2 things.
Right.
One is that isn't it the date that matters? If you notarize date, and then the date that is the latest is the one that is going to stand automatically.
That supersedes the old one, correct?
Right. So, and then the second thing is that you can tear up the old will and nobody will have access to it.
Correct. You could do that.
Yeah.
Correct.
Yeah. Okay.
Correct. I mean, it's if you think of it like you're leaving instructions in your office when you're not there, and one instruction says this project is canceled, they are never paying us, so we are not going to do it. Stop the whole thing. Another document says, oh, these guys are great, and they gave us so much money, and now we're going to be working on it. Now, if you're not there, a new project manager comes in, what is he supposed to do? Work on it or not? I'm sorry?
Latest date.
Exactly.
The latest.
Exactly. That's what I'm saying. So the date is one thing. Again, not complicating the topic. When you notarize it with a third party, not your cousin as a notary, a third party like a AAA, something like, an unconnected person to you, right? Or when you go and register it with the county, those things matter. In other words, if let's say, I'm just going to paint an example. If somebody says, I have a 2010 will, but I have registered one in 1998 with the county. 2010 will looks shady. Let's just say the words are not like the way we would have written. It's not clear. You can clearly see the beneficiary in this new will dated 2010 is your neighbor. And the neighbor is the one that's contesting, saying, I found a will in 2010. Well, if you're the judge who's going to look at the nefarious act of somebody bringing in to claim as a beneficiary on a handwritten will or typed up something that looks kind of shady versus a notarized registered document in Montgomery County that is from a lawyer that's not your cousin, place more weight. Okay, that's why it's better to set these things up. Lawyer's office also is a good way. When you hire a lawyer, they have an escrow document capability to keep that in there, right? So they can be called upon. Of course, the survivors have to know that, look, I deal with this lawyer all the time. In case you need anything, call them and then they'll have the document.
Correct. I think typically a copy stays with the lawyer and one with the primary physician's office.
Yeah. Stuff like, again, you're trying to spread it to reputed people so that if they were to be challenged, court looks kindly upon you. Nothing guaranteed, right? Again, if the other lawyer is Johnny Cochran, they can prove anything, okay? But again, 99% of our cases, clear instructions, keeping it simple solves our problems. It's not like, there's a Tesla stock in our portfolio of, 1 billion worth today becoming 100 billion. Now it's worth it to fight it out, So anyway, going back.
I just have a question on the same line.
Sure.
So when you are saying registered with the county, so in county, is there an office where they register things like this?
Yeah,
or?
Yeah, they do.
I see. I mean, is there a specific name for that office, or?
You go
I
through a
can
lawyer,
find out
he'll know
exactly. I
everything.
mean, every county has differently. In Montgomery County, I can find out and give you that.
I see. And then see, like in India, the will that you have that is just signed between by yourself doesn't really count, right? It has to be registered in a government office. Is that correct
No,
or
that's
not?
not true. In India, it needs to be on the stamp paper and witnessed by two people is good enough. In fact, it's not even stamp paper. If it's white paper, it'll count too, but other people can challenge. But if it's on the stamp paper, notarized with two witnesses, it doesn't have to be registered. It's okay.
But
But if you
Dharmender,
register, you're
Indian
better.
laws are totally different. And I don't think we should go into those because I think the topic of today is primarily in USA, right?
No, let me look. The act is saying the
Well, let me
intent
tell
is
you,
saying-
Indian laws are totally different because I know that. I have gone through that process. For example, if your wife dies, your property immediately goes to your children. Can you believe that? You have to, they own the property immediately. Like I have a house in India, and supposing my wife dies, that house, if I have to sell, my children have to give me no objection certificate because they become co-owners. In USA, it's nothing like that. So it is totally different. Why should we go into those Indian rules and regulations?
Yeah, probably that leads to a question, Mr. Dharmender, that will people who have property in multiple countries, like I may have property in Canada and I have
Right.
yeah. So do I
Those
have
are
to have
different rules in
separate will?
each country. You know.
Will register in two places.
country at a time.
So let us keep our discussion to only USA, I think.
No, that's right. Okay. One thing I don't know exactly to say yes or no to you, but one thing is it's always better to keep a tab of all assets, international or otherwise, in one place. So at least you know where to go and who is
Yeah,
getting
that's right. There's a common sense that you have to keep
just
travel.
as a best practices. And the second
Okay.
thing of if you it doesn't take much to register in the jurisdiction that property is in, right? So if it makes sense, meaning if it's a lot of money, you probably are advised, I would say, suggested from my side to take a professional help in making sure all of that is done right. Now, if it's a nominal amount, cost benefit analysis doesn't speak that much because even the person who's going to challenge for a $15,000 in Canada, I mean, it takes a lot. You know what I mean? A person has to be litigious to do those kind of things. If every person's behavior changes when the amount of money involved is high, okay? So the risk of you getting into issues become high when the amount is high, thereby a professional probably is needed to make sure all of that is tied up. Okay.
Yeah. So Vinod, you just volunteered yourself to conduct a session for estate planning in India.
Good one.
Look, I love this planning. All right, as much as stocks and all is good, planning for what to do while things are in motion, especially when there's a play to be made, is interesting. So,
Hey, Dharmender,
okay.
the question, let's say we have one will, right? And so can that still be challenged? Like you said, that, they can claim that, oh, it's not equitable, right? But is that even,
Strictly speaking, if you go by the law, once it's written in the will, it is not challengeable at all. The court will decree in the favor of the person who is unduly getting 90% of one asset, and that person can basically go and establish that it's 90% is theirs. Nobody can stop. The unspoken issue of how do you fare between your relatives when you got 90% and your brother got less, that's an unspoken field. How you solve it is not the law issue or a will issue. You know what I mean? That I know many people who will say, forget it, they wrote and I got it. Maybe the person wants me to have it and have it. And you could be sour about getting less, but that's what it is. And you'll be right in saying that. And nobody can challenge that. It's not, there's no court that will not recognize a written word.
But hypothetically, Dharmender,
Yeah,
if you write that your property is going to go to your kids,
yeah,
you wrote it in the will.
yeah.
Who potentially can challenge this?
If it is unambiguous, answer is no. But
So
if
most
it
of the
is
time we are writing it to our kids, so nobody can challenge this, right?
correct, in that simplest unambiguous circumstance, answer is nobody can challenge.
Good. Let's keep it simple.
Right, right, right. As I said, 99% of the situations, you won't even come to that far. So a clear terms of who gets it, especially when you let the people know who gets it, that's one way to do it, right? And there are other ways I'll keep showing you the other ways.
Yeah,
Probably the
so
better
when
way.
there are multiple spouses and all that, only then it gets complicated.
Yeah, it gets
So,
complicated.
Dharmender, I really like this slide. The only thing I would contend with is the first line, right? So, how to avoid probate.
Right.
I know you explained it, but as a slide, will does not avoid probate, right? So, typed will does not avoid probate
No, I'll
because
tell
will
you
has
why.
to go through
True,
probate.
true.
No, I'll tell you why. If let's say you hand wrote it, again, 99% of them, none of them will happen. But let's just say, I'll tell you where that gets interesting. If the terms of the will are unclear, or you have a house and you're basically saying it on a Monday till 12 o'clock, one person gets it on a Saturday, somebody else gets it. You just laid it out in a very complicated way, let's just say. Or you wrote it down, handwriting like a doctor, and somebody reads it, can't make sense out of it. Or you're basically saying, my son should get it, but then you have 5 other illicit sons. Are they sons or not? Okay. When those things happen, somebody
That's
can
true.
somebody
So
can
what I'm saying, Dharmender, is
yeah.
that typed will with clear terms and beneficiaries has to still go through probate, right?
Everything
So
goes through probate.
Yeah, unless you go for a trust.
What I'm saying is everything goes through probate. Maybe
correct,
just for a
correct.
second.
I'm just saying that the title is and it doesn't match with the first line. That's all. I
Oh,
know
you
you
mean-
explained it.
Okay. You're saying
Yes, Nari, I think, Nari, you are right. Even a clearly stated will after the person's death should,
Yeah, has to go through probate. Yeah.
should be
Absolutely.
filed. Let me finish. Should be filed with the state, and state gives 30 days or whatever the rule is. If there is no challenge coming in those 30 days, then whatever will says is implemented by you. So that
right. Again, what I mean here is a probate is an act of distributing initiated by the government, as in you didn't speak for it, they have to allocate a administrator. That's what I mean. Everything really goes through, even for a second. That's what an act of distributing and recognizing who gets it. It's almost like in old English days, a person will come in with a suitcase, and the guy will open up the will and read, and everybody's sitting across the room, and they go, "Oh, my father left a knife for me," and somebody else says, "Oh, he left a gold coin for me," and that's what the person who's reading is, quote unquote, acting as a probate, although it's not appointed by the court yet. But that person is going to distribute, this is your gold coin, this is your favorite knife, Zippo lighter, all those, that person is going to do it, right? So
Yeah.
clearly
Dharmender,
typed up
one
will.
question here.
Hold on a second.
You have written how to avoid probate. And you have not listed by creating a trust. And
Well,
I
here.
think that is the best and the simplest
Yeah,
method
No,
of
he has.
creating a trust, but you need
Second.
legal help. So if you do that, you can avoid probate.
Irrevocable living trust. He's
Yeah,
written
the
that.
second item is the trust.
Yes, that is very, very important. That's what I said. We should understand that because trust really eliminates probate.
Right.
Right.
That's what he hasn't gone to the next slide to talk about trust yet.
I know that. Because he's saying how to avoid probate. But I'm saying you are not mentioned here. The best method of avoiding is by creating a trust.
By the second one is that right
It's-
after the
it's-
type.
it's
You
still
see the
there.
second.
Okay.
I'm confused.
Let's
I'm
go to that.
confused. Nari, you brought in a point that made me confused. And Dharmender is saying that if you wrote a will, there is no need for probate as long as the will is clear. And you are
No,
saying
it
that
has
even
to.
if you have a will,
No, that is
go to probate.
contradictory actually.
Let me say it in a way. Maybe this clears it up. The act of probate, in a strictest legal sense, of act of distributing, happens for everybody, right? Whether you have will or not. The in a colloquial sense of avoiding the probate means the first threshold of the will and all these ways of, if a person clearly speaks, as I said, what is falling into the safety net? In other words, if things are already spoken for, then there is nothing on the safety net that falls through. What remains unspoken is what's called what's the action needed is probate. Okay, so if you spoke for it already, there's nothing remaining. Thereby, there's no that you avoided probate already. You know, when I say avoided probate, there's no need for court to appoint an administrator to think about how to distribute.
Yeah.
You see what I mean? Fact that the assets have to be distributed, you're already in the phase of being in probate. But first 5 minutes of it, if all assets are spoken for, there's nothing more after that. The act of distributing under probate, which is a costly affair, is what I mean by that.
Yeah, that's exact. So what is so bad about probate that we need to avoid it? Maybe if you look at it that way.
Okay,
Right,
yeah,
okay.
there are a couple
Yeah.
of things, right? So
Okay,
probate,
yeah,
you have to
let's
go
do that.
through court, and it costs like 3 to 7% of the asset value.
Exactly.
Right. And also what happens is court decides and appoints an administrator, and that person is a third party administrator, and that person is going to cost you like a lawyer, right? And that person is in charge now fully to make the decisions. And that person is not only charging you
Not,
the services fees and everything else, but that person may be saying, look, I think this Zippo lighter should be given to the third son, not the first son. And that's it. You can't really challenge that.
And
Let me
also,
ask you a clarifying question.
and also costs time. See, in addition to money, as Nari pointed out, it will also cost time. So if
Correct.
it goes
Yes.
through the
It's
probate
the-
process,
Right.
the
Yes,
time could
yes.
be a very major factor.
Yeah.
But Dharmender, tomorrow I die. Okay.
Yeah.
In my will, clearly I wrote that my property will go to my sons.
Right.
I have written their names also. There are no illicit sons.
Right.
Okay, their names also written. Now, after my death, they take my death certificate and my will, and can they go to the court and then transfer my home into their names?
Exactly. That is the process they will be following. Correct.
They will not be going through probate.
They will, in
That
other
is probate.
words, the
That is
fact
probate.
That is probate.
that act of
Going to court means probate.
No, probate means it involves expenses and all that stuff. In this particular case, there is no expense
Exactly.
involved.
The first point is to go to
That
probate.
is why
process.
we should go to trust
Then
as
it
early as
goes to
possible.
distribution. Now, what Dharmender has understand saying that the detailed process of going through here, it goes to probate is very clear, matter decided, very limited time required, and very limited money required. But if it's not clear, then it can go through a long process. So it always goes through probate, but decision in the first case is very quick and fast.
It'll be
Great
not even the person at the window when you go and submit these, that person will be saying, all right, you have a cushion of 150,000 unspoken for that are not tallied in any of the will. So they'll go, all right, will says this, and then they'll give you the method to transfer the home ownership to the sons, and the remaining assets, if they are all tabulated and comes out to be less than 150,000, they'll say, this is it. You can just get it. If it
let me take a couple of
Do I
minutes.
pay anything at that time?
I think
Do I pay anything at that time as a fee?
people are unnecessarily worried about the word probate. I think that's what creates all the problem. as we have been talking all this time in this presentation, if you state everything clearly in the will, and also all your accounts in Vanguard and 401k clearly states the beneficiaries, even when you submit everything to the state, there is no need for probate. Probate is the strict definition of probate that you should worry about is when the court comes in and decides who gets what.
Exactly.
Clear.
Right.
That is
Otherwise,
not
don't
correct.
worry about
Step
going
two.
to,
That is
don't
not
worry
correct,
about
Vishal.
going to the state and then ask them to approve, put a
So
seal of approval. That's all.
no, I don't think it is correct, Vishal.
No,
So
I also agree with
so
Nari.
Dharmender,
I
Let
don't
go
think
to,
it
go
is.
to
Dharmender
that slide. Go to that slide where it says what is probate.
Now let Dharmender
Yeah,
say
let's go back to that.
wrong.
Yeah.
So okay, so just give me a chance, guys. So here in the second line, it says assets are distributed after expenses and debts as per the will direct. So that is still probate. So
Yeah,
even
but
if there
again,
is
what
a
I'm
clear
saying is,
will,
it's
then
not
it
something
is
that you should worry about 3%, 7% of the asset. No, it's clearly stated. Only
Right.
state has to come and decide because it's not clearly stated.
Exactly. It's a step two that we should be worried about. Step one is a consequential thing. It's an inconsequential thing. It just happens. It's as much as just following the flow chart and boom, it happened. There's no
no.
complication.
See, the whole purpose of estate planning and everything, like Vinod said, they highly recommend you create trust and move all the assets so that to avoid probate, because the will is called a pour over will, right? So whatever is left, that is what is going
Nari,
into will, and
I
whatever
myself.
goes
what are you
whatever
Yeah,
worried
goes
about
into
yeah,
will.
Nari,
Nari,
going
I
to the
also
state?
support you.
What are you
I
worried
spend a lot of
about,
time on
Nari?
this.
If everything
And
is
finally,
stated
I
in the will,
concluded trust is
just
the best
putting the
method.
application or the paper, I mean, to the state, and they will put a seal of approval because everything is clearly stated, and you don't have anything more than
Correct.
150,000 that not stated. Why are you worried about that?
Correct. Well, we'll come to two more slides. Maybe you'll change your mind. But again, 99% of what you said is right.
Let's move on. Let's move on.
Okay, 99% of what you said is right. If things are all clearly written, whatever, in other words, if there is nothing left over, okay, complication only comes that which is left over. Okay, leftover is when leftover, that too, more than 150,000 is when court will step in. As long as you don't need court to step in, you're fine.
Yeah.
All right, let's go to the next.
This is where some of the people say that probate can be avoided by trust. I went to two lawyers. They said, look at my will, and they asked me the question, do you have anything that you worry about that the state will come and distribute? I said, as I said, it's only my furniture and drapes and my laptop. They said, don't worry about it. Then you don't need any trust.
99% of the cases, I think what you said is right. In the will, if you clearly state who gets what, including you can go one more step, right? Which is you could be actually identifying the owner, or even transfer some part of it. That's a different topic. But I'm saying writing down in the will triggers the action. Survivors have to go to the authority, show them and say, all right, now the deed has to be transferred over to my name. And it triggers the taxes. There are lots of things that happen. But from our point of view of writing things down makes it easy who gets it. Okay. Anyway, so joint ownership of the property is another way, which is when one owner dies, the property goes to the other joint owner. No probate is involved. This is what I was talking about. So if you have other person in the will is one example, or identify the second person, put them on the owner, just like putting beneficiary in the TD bank account. It automatically goes to the surviving person. Or you could be thinking about gifts. Basically, the idea is you plan your estate to limit the ownership to non-probate assets. In other words, if you don't have anything to fall unspoken for, fall into the safety net or final net, then you don't have anything to worry about. All right.
And also, Dharmender, is it right that 401k and IRA automatically goes to the spouse after you die?
Right, right.
Spouse, yes. Okay, but if you have the beneficiary, that overwrites it. But then there's a whole tax complication that comes in. We'll go through that. There's a estate exemption, lifetime exemption that you have. They all have to fall within it. If not, the other person getting it, you have to pay taxes. There's a whole to it. But anyway, as I said,
one more question, Dharmender. Sorry, I will.
Go ahead.
In India, when I have, let's say, a fixed deposit account.
Yeah.
So a joint account, but still they actually always the ownership goes to the first name.
Correct.
Compared to that,
India is totally different.
Indian fixed deposit.
Don't go
Yeah,
into India.
India will be a separate session with Vinod.
Yeah, you know,
Okay.
Nari, that gentleman who conducted, that other estate planning from
Yeah.
India, he is the right person. Because I am also not that familiar.
Let me
I
give
only
you-
know what I went through. I can share that. But
What-
that gentleman knows everything.
You can comment on later on. Well, just hold on. So my question is this: are the account with a joint ownership versus an account with a single name and beneficiary as your spouse?
They
Are
both
they-
do the
are they
same.
equal? Are they equal?
They both do the
Yeah,
same.
even if it's in your wife's name, still the children will get it.
Okay,
after
and I'll
that.
give you one little example. Okay.
Don't confuse me. I'm asking you, are these in terms of distribution later on? One account is joint account.
Let me
second
give you
account-
joint
As I
account.
said, we should consult somebody from India. That those people know the rules.
Yeah, I don't think
But
we know.
it's
So
better not
let's
to.
move on. We
because we'll be
we
talking
only
half
have
the
30
knowledge.
minutes left.
Okay.
We have to cover trust. Let's keep moving.
Let's
hold
not
on.
talk about India.
Otherwise, we'll go in a wrong track.
Hold on. So now going back to your question, the difference, although they both serve the same purpose, the difference is when you have a joint account, the second person automatically gets it. You don't need to prove anything. They have the signature authority. They can basically operate the account. Okay. But if you have the beneficiary, it creates the work of proving that certificate that the person is no longer there for the institution to transfer over to the beneficiary.
Dharmender, you're talking about USA, right?
No, I know in India.
Oh, India. Oh my God. No, I don't want to. That's
Hold on.
horrible. Oh, those rules, my God.
Vinod Bhai, hold on.
Once only you have to experience to know what it is.
Vinod Bhai,
I had some experience.
Okay. I just have gone through it very recently.
Oh,
so
you just went through.
Okay, so let me speak.
No, but why we are going into another topic? That's a different topic,
Can I decide what topic I'm going to be presenting?
No, India, I'm
Yes,
trying to say.
yes,
that,
yes,
if
Dharmender.
not, then,
Yeah, Dharmender,
we
you
will
are
have
the
to have a
boss
separate
here.
for
Vinod
trust.
Bhai,
Trust is very
Please,
relevant to all
keep-
of us.
hold on. If
Hey,
I
guys.
have the knowledge, okay, Vinod Bhai, please. If I'm speaking about the current example that I know what's going on in India, which is in the moment the topic applies, it is a worthwhile thing to spend time on. So let's go through that. And
Yeah,
give me
sure.
time that I don't have it. Okay, so let's just go through it.
Go ahead.
Okay. So whether it's in India or here, it applies the same, which is this. If you have a beneficiary on the account, the beneficiary has to show that they are the surviving. That means there's a work they have to go create. I mean, they have to go attend that, show it to the bank, show it to take a death certificate. As you can see, institution has to honor that, right? Whereas if it's a joint account, nobody has to honor anything. You're already there. You can transact as if nothing happened, okay? The reason I say that,
thank you.
India, right now, banks are not just taking a death certificate and say, all right, I'll just give you the beneficial. They are now basically saying, go to the court, get me the instructions from the court. Now, a step involved in court is not like 8 years. It's still 15 days to 30 days, and there are steps involved for the court to move. You have to basically go show them the death certificate and what's called There are steps involved. Okay, so it's a
Yeah.
30-day process, and then the court will say, fine, this person is recognized to be a beneficiary. You go take it to State Bank of India. State Bank of now is going to move it to you. So that if you want to avoid all that, joint ownership is the better.
Thank you. Thank you. That clarifies. Thank you.
Thank you. Okay.
Can I ask a question on that?
Yeah,
let's
go
say,
ahead.
let's say if you don't have the joint beneficiary, but you're operating the account, you have the password, and you've been doing, let's say, for your parents without being a beneficiary, would that be illegal once they pass away?
Answer is, I don't want to say it, but it's illegal. Because you're acting on behalf of the person, right? Although the person might have authorized you, but then that authorization goes away when the person is no longer there. The latest example is, remember that young guy, Brian, somebody who was who choked the girl in Utah, and he uses her debit card on the way back to go to Florida, like a month or two ago.
Brian Landry.
Brian Landry, right. And then FBI, of all the things they want to book him, they could only book him under that. Which is he used the debit card of that person after the person is deceased.
Yeah. They booked him under unauthorized access.
Yeah, something like that, right. Okay, coming back to the slide number 22. By the way, we have 54 to go. I mean, total of 54. All right, estate planning sets up a transfer of assets, not income. This is kind of, again, 99% of us probably don't even fall into this category, but the assets that a person has, when you could be thinking of, you could be speaking for what you're going to be doing with it. But if it's the income that you're deriving, let's say Social Security or pension, those are governed by the laws that are outside of you. You have no control. If Social Security law says spouse gets it under certain situations until they are remarried. I mean, there are all kinds of things that kick in, right? Can only sometimes leave your income to one person, which is your spouse. You don't have a choice of giving it to beneficiaries and all that. Okay, so the assets is what you have more control over, of assigning or giving it to somebody else. Capital gain taxes are usually lower than the income taxes. That is kind of obvious. We can trade or give your existing stuff to other people and change its nature, if because there are assets in there. So the transfer of assets outside of your will, meaning if it's not spoken in your will, what happens? Well, there is operation of law comes into picture. They decide who gets what, and I mean, it gets complicated. So the law basically has already figured out who receives the property the moment you die. They know it already, okay? The only thing you need to collect the asset is an original death certificate, if you are the beneficiary of it to prove. So living will trust, what is not transferred? Wills do not transfer property that has successor ownership that is known at the moment of your death, meaning anything that already has named beneficiary. Okay, so just because I basically, it's like me saying right now, I want to give TD Bank account to somebody else. Well, I could have my wish. I could write it down. But if TD Bank only knows that there is a beneficiary named already, they would go by that more so than my wish, because I should have acted on it. Then they'll say, you didn't act on it. You already said who the beneficiary is. That order of precedence, they get. So these are various things that you could be putting the beneficiaries on: life insurance, IRAs, 401ks, pension plans, bank accounts, joint property with the right of survivalship that includes your house, bank accounts, brokerage accounts, transfer on death, or in trust for accounts, which is another way of triggering something at the time after the death. Trusts, contracts, these are all that you could be thinking about. Any questions till now, or we're doing okay?
Hey, Dharmender, I have a very quick question. I'll make it very quick. Recently, in Montgomery County, I went through a trust transfer. I mean, will transfer. A person died, and he had written a clear will of who gets the assets. It was only one person.
Yeah.
And we went through to Montgomery County Registrar of Wills and the Orphan Court where they did the transfer and everything.
Yeah.
And a lawyer who wrote the will is the same lawyer we hired to do the transfer. The will was very clear.
Mhm.
There was no contention, nothing. But the lawyer charged 2% of the entire estate as the fee to do that, even though the will was very clear. Is this
Well,
normal?
answer is you
Yeah, I
probably
think
didn't
it
need
is.
that.
Huh?
Answer is you probably didn't need him to do that.
I didn't need the lawyer at all.
Yeah.
So I should have helped the lady by doing this myself personally rather than using a lawyer.
Yeah, you could have. I mean, thing is, generally they want about $2,000 to $5,000 just because they got involved for anything, right? That's their going rate. If the 2% translates to much more than that,
did.
we could have negotiated. Or it's probably worth it to invest some time understanding the logistics
So
of
there
how
is
to carry
no,
that
there
and
is,
do it yourself.
but the lawyer talked as if that percentage is like common.
Well, it is common, but it doesn't have to be.
Okay.
My lawyer tells me that it is 1.5% if I go through him. And he kind of indicated that we should go through him. And that's why I was asking all those pointed questions about, can my kids go directly to the court and then transfer it on their own?
You could. There's nothing that prevents you from going directly.
Okay, good.
Again, if the instructions are very clear that your survivors can just follow the instructions and go, and there may be 4 steps that they have to go find out what to do. It's like booking an airline ticket, right, to go to India and come back. If you just ask my 10-year-old, she's not going to know how to do it. She probably will hire an agent to do that. But if we invest a little bit of time, it's not that complicated.
I
One
think
question,
that's where they
and
get you, the convenience factor.
Naveen.
Yeah.
Uh,
And also the agita and anxiety that the survivors go through, saying, I don't know what to do and how am I going to get it? Is it registered right? That's where they ding you.
Where do you go with the will? You go to the state or go to the registrar of the county?
Bala, you probably had an experience. Do you want to speak to that?
Yeah, we went to, believe it or not, in Montgomery County, it is called the Registrar of Wills and Orphan Court. That's what it is called in Montgomery County in Norristown. So that's where we went to register the will, and the lawyer took us there. I didn't know anything about anything, and I was helping the lady, and 2 of us plus the lawyer, 3 of us went to the Registrar of Will and Orphan Court, and they gave us some sort of a letter, about 10-15 copies of the letter. They called it some funny name, which basically said that the person who owned the asset, he had assets all over the place in Merrill Lynch, in Putnam account, and all kinds of accounts, and every bank accounts and everything. And every one of them wanted this certificate of proof that this person is inheriting this account.
Yeah.
And through that we went. The lawyer did do a lot of work. I'm not going to say he didn't do the work, but it looked like 2% was a little too much. And that's why I asked whether it is a standard thing. At the time we agreed with him because we didn't know him better.
I mean, sounds like
Understand that.
1.5. I heard 1.5 was the number. Sounds about,
No. We paid 2. I mean, not
I'm
me.
saying if 1.5 is what other gentleman said, 1.5 to 2 is not that big a jump.
Yeah.
It's
We
not like
paid
0.25 is what I'm saying.
Yeah.
Another variation of the subject, Dharmender, is we said in will we have to write everything down so that everything is spoken for. Is it not the same thing valid for trust?
It is, but trust sits higher than will. In other words, in
That means-
trust,
that means
you
what
could
you're
put
saying
100
is
assets in there.
everything that is you have assets must be inside the trust. Otherwise, things which are outside the trust, because you may not have put everything in the trust. In that case, you may have, similar to the will, many things not inside the trust. That's my question.
Correct. And if you if you extend what Bala was saying, the need for that lawyer to get involved and do the work because it was not in the trust. It was listed in the will, but then somebody has to carry the work that's needed in transferring the Putnam account and this and that. They all have to be doing that, including a certificate has to be, obtained that authorizes such a transfer. So it's a work. Somebody has to do it. If it's already in the trust, those are already spoken for. In other words, that lawyer had less work to do.
Now, I understand that. My question is the main, that means all your assets must be inside the trust. Then only that is what can be distributed by the trustee, chairman, or trustee, whatever is there. But it may happen when you created a trust, you had X number of items in the trust, and there are few items not spoken for in the trust, just
Correct.
like you said about the will. So I think similarity is there. You might have left out something in the will. Similarly, you might leave out some certain things from the trust.
Exactly.
Yeah, but still go through probate for the things that are not on the trust.
Correct.
Yeah.
Correct.
Dharmender, I just had a question pertaining to the authenticity of the wills and the trusts.
Yeah.
Like, I mean, I have a document that's been notarized. Is that still valid, or does it still need to be registered at a court?
If it's registered, it takes away that much ambiguity. Now, court recognizes a notarized just as easily as it is registered. All these come into picture only if the beneficiaries contest and who will consider something to be authentic versus not.
Okay.
From the court's point of view, they'll take it.
Yeah. Okay. Thanks.
All right, going back to the slides. So the original written or typed legal document just helps for for making it easy for ourselves. Signed by you, witnessed by disinterested people. Now, this is a kicker. If it's witnessed by the interested people, as you can see, somebody can protest and court will be looking upon kindly for that protest to say, well, you witnessed and you are the beneficiary, maybe you put a gun to that person's head, stuff like that. Best thing to do is unconnected, unrelated, a third party should be like a professional of some sort, should be the witness, that, they can say, yeah, I was there, that states who receives assets still in your ownership after the death. So clearly your leaving instructions. And the names a legal representative or the executor to wind up your affairs. Now, going back to the example of that probate discussion we had, executor that you specify is like saying, my brother, and that person is going to read, is going to make sure that they are carried forward the way we write it. And that's, if none of that was there and your assets tabulate to a point where code 6 unspoken assets are high enough that I'm going to assign a probate officer, that person is doing nothing but being an executor. Just that they charge the money back to you, into your assets and start draining. And the law recognizes that they need to be paid first. Remaining is what the beneficiaries get. So as you can see, they sit ahead of in terms of lineage. Plus, can name a preferred guardian for your minor children that is submitted to court that oversees the probate process. Basically, just to, as Bala was saying, it's better to have it in the same jurisdiction so ambiguity goes away, and and at the time of your death,
What is the meaning of that point? At the time of your death?
No, I think the 7 and 8, they should have been just the same one. I probably put a enter here too soon. Only prohibited if money or guardianship needs to be dealt with. Meaning, if there are assets, including guardianship, okay? If court decides that that's who needs to get involved because too many people are fighting over who gets it and it's not clear, and this independent person is going to step in and and decide who gets what.
Hey, Dharmender, I have a question here with respect to at the time of death.
Sure.
So someone had told me they had a case they went through in their family where they had to kind of get last minute signatures from the person who was dying, who was not quite conscious enough, but somehow they got signatures and wrote up a will.
Yeah.
Now, and then sort of got it witnessed, signed by disinterested parties after the fact, right?
Sounds fishy already if I hear as I'm hearing.
Yeah, sure. But the thing was that it was all within the family. There was nobody to contest it or anything. It was simply to just get matters properly solved.
Okay.
My question is, is there some legal requirement to submit within a certain period of time, after death to the court?
Well, the answer is no. There's no clear timeline of doing it. But then, who is paying the taxes on your home if it's not already distributed to the rightful owner? You know what I mean? So it's better that it's done sooner than later, but there's no timeline for that.
Okay.
Yeah.
All right. Thanks.
So Dharmender, time check. I think we can close today after you finish wills. How many more slides on wills? Because trusts we can do next week also, next Tuesday, if you are free. Or we can stop in another couple of slides. I don't want to go beyond 9:30.
Yeah.
Dharmender, just a question. I mean, this is not pertaining to after death. This is pertaining to life.
Yeah.
I mean, when you're living, and this is probably part of your estate, planning presentation, but if you want to transfer, some of your property or assets to your children, how do you do that, and how is it seen financially from a tax and other implications standpoint?
Yeah, I'll give you a brief, and it's kind of segue to the next time because that's where it gets really interesting. Okay, from all the strategy point of view, the setting it up as a revocable or irrevocable makes a difference. Okay, now while revocable is easy to do, and from a tax point of view, whoever the creator is still paying the taxes at the same rate. So revocable has no real benefit from a tax point of view. But if it's an irrevocable, it's a separately different entity. Okay. Now, The problem, and this is where I'm sure we'll have lively discussion next time we have a session, probably even a couple of sessions. All right, it's like all the strategy that you talk about for picking a stock applies here. Okay. Anyway, going back to this, the trick here between revocable and irrevocable is this: the tax benefit and the from the credit collection point of view, all the benefits that you get for a irrevocable trust comes with one negative, that once you create the trust, you no longer can be trustee to it. You no longer can be beneficiary to it.
Mm-hmm.
Okay? So in other words, if let's say today you created a trust, you're the creator, and your house, you gave it to the kids. You now have no say in it. You lost control on it.
Mm-hmm.
And you cannot even be the beneficiary to it. Okay? So there's a lot of planning that comes in how do you take advantage of what it gives, but not be hampered by it because, you know, what if you need it tomorrow? And then you don't like your kids anymore. And you thought, you know, some way you were going to make some windfall of money. And now, you know, you can't give up the house like that. So all those uncertainties is what makes the irrevocable trust complicated to set.
But
and
from
understand.
that point of view, that's the better one, even though
That's a night and day better. And it gives you the shielding. In other words, the whole reason that you do trust, which of course for the probate point of view, but from the planning point of view, is if somebody were to sue you, they can't get access any of the assets in there. So as you can see where I'm going with this, one of the best mechanism for wealth protection is that. But then it comes with the downside that I cannot be the beneficiary. So how do you play the game? That's where, if you understood where IRS comes into picture, and how far arm's length can these beneficiaries need to be, and you know all that gets interesting.
Yeah.
All
So,
right. Yeah. Look
so
forward to that.
Dharmender, do we want to start from this slide next week? Are you available next Tuesday?
Let me check. In fact, I had to go to Texas. You know what? 8 o'clock, no matter where I am, it's fine. Why am I even checking?
Okay. So I think this is good. A very good discussion. I think everybody learned something new. Maybe raise some more questions, but I think overall I thought it was very useful. Thank you, Dharmender, and we will continue next week. I will send out a new invite for next week. I think we had another thing planned, which was mine, but I will postpone that. I think we need to continue with this, persevere with this, and finish.
Estate planning, especially accumulating assets, is one thing, and we all love accumulating assets.
This is much more complicated.
Right. To secure the asset that you accumulated, how do you plan? How do you not get into tax scenarios? How do you?
And after all that, we haven't even gone into tax considerations, right? So you have the inheritance tax.
Believe me, if anybody who's got a lot of money, they are not paying estate taxes. But you would say, well, you know.
No. See, there is estate tax is one thing that is like currently 11.5 million, but you have the Pennsylvania inheritance tax as well, right? So we need to cover all those things.
Right. Yeah. Right. No, I'm saying even if once you cross 25 million between husband and wife, 40% tax. Okay. You think Rockefeller paid 40%? You think what's his name? Obama is already in 100 billion. I mean, you think Bill Gates is going to pay 40%? No, they pay zero. Well, how are they doing it? That's where the interesting part comes in.
Yeah,
Just last one small question.
Sure, sure.
I think when we take any legal help, it has to be state dependent, right? Like if you are in Pennsylvania, you can't use a New Jersey lawyer. You have to use somebody from your state, right?
They have to be licensed in that.
Yeah.
Yeah.
There are people, you have to take some legal help somewhere, I think, to be on the right track.
Correct.
You
They
have
need
to
to be
get in touch
licensed.
with your own state, attorney or whatever, tax consultant on this.
Right.
Yeah.
Okay, we'll talk.
Look, most of what I said, I made sure what I said is 100% true, but things change so fast. If at the end of all these sessions, if it gets us interested in broaching the topic, that I think is a beneficial, worthwhile effort for all of us.
Basically, a liar, if you take a proper liar at the same time, I mean, the path becomes smoother for your children.
Right. At least you know.
You have to
It's
take
like,
the pros and cons, yes.
yeah, I mean, it's like going to a doctor when the doctor says, I got to cut your leg. At least you know, some
Exactly.
information before that. Why does he have to cut your leg? Oh, because I had a type 2 diabetes.
Liars are much worse than doctors.
Good. Okay, I'm going to stop recording now.
Great.
Okay, thanks, Nari.